Wonderful. Well, hello and welcome to the 2022 Intellectual Property Speaker Series presented by MIT Technology Licensing Office, and MIT Libraries. Today's session is the ever popular Basics of Copyrights, Data, and Software with speaker Dan Dardani. My name is Robin and I'll be your host, and Aidan Fowler, Technology Licensing Associate, will be your Q&A moderator. Please note that we are recording today's seminar and we'll be posting the recording and the slides online after our series concludes. So before I give the floor to our speaker today, a quick introduction. Dan is a technology licensing officer at the MIT TLO with 18 years of experience managing a large and sophisticated portfolio of computer and software technologies, including algorithms, digital imaging, video games, machine learning, AI, and cyber tech innovation. So quite a few. Dan has negotiated countless license agreements with companies large and small. And Dan is a certified licensing professional. He's a teaching fellow at Harvard University Summer School and is quick to lend his expertise serving on professional committees and advisory boards in the area of software licensing and intellectual property. So Dan, thank you so much for being here. I'll turn the floor over to you.
Thank you so much, Robin. Hopefully everyone can hear me and see the slide. Welcome and thank you all for coming. I can't really see all your faces out there, but I trust you are here. Thanks for spending your Friday morning with us. My pledge to you is after this session, you're going to know a lot more about copyrights. Unless you happen to be a copyright attorney in attendance, then you'll probably walk away with equal amounts of knowledge. But for those of you eager to learn coming into this at perhaps beginning or medium level of education on the topic, you're going to be a lot better off afterwards. That's my pledge. We're going to talk a little bit about history, philosophy, and of course, some legal nuts and bolts and some technical insights along the way. So once again, my name is Daniel Dardani. I work at the MIT Technology Licensing Office. The TLO, for those of you who are not familiar with MIT's community, is responsible for managing all of the institute's intellectual property assets. All of the cool things that MIT is responsible for sort of birthing kind of flows through our office, hopefully for protection via intellectual property, and then ultimately to try and bring it back into the public through various vehicles like license agreements and other types of technology transfers. So really, really fun stuff. And if you are involved in the research endeavor on campus and would like to learn a little bit more about what we do and why we do it, please feel free to follow up with us. But back to the topic at hand. So today, we're talking about copyrights. So there are 4 types of intellectual property. Patents, as we know, protect inventions. We think of those as kind of the leading or bleeding edge of technologies. Copyrights, on the other hand, we're going to see protect a slightly different class of things, namely works of authorship. And works of authorship are a little bit more closer to home because we experience them perhaps a little bit more every day than we do, latest and greatest inventions. Copyrights include books and magazines and movies and songs and art, literature, lots of things that you would probably encountered dozens of copyrights already just in your morning if you've read a newspaper or browsed online. Trademarks protect brands, how people advertise their products to consumers. Trade secrets protect strategically important business information. But today we're going to focus on this one, copyrights. And I always like to start this talk by kind of showing this picture because we always think of intellectual property as a uniquely modern or uniquely sort of cutting edge. It's what's happening tomorrow. It's sort of looking over the horizon at what's next. That's what matters for intellectual property. But I really think in order to understand intellectual property, any of the 4 assets I mentioned, we also have to take a step and look back because intellectual property was just as important as a concept in the beginning than it's going to be relevant for our society moving forward. And here we have a picture of Jefferson and Franklin and a bunch of the founders. And it's important. I always think it's fun to think that, really intellectual property, at least in America, the story starts with our founding fathers, because they're the ones that really ingrained the sort of system that we've inherited over the centuries. So this intellectual property was very much on the minds of these guys in this painting, and still very much on the minds of us today. Now, like all good ideas in America, we borrowed them from someone else, right? It's probably the first evidence of copying. We're going to talk about copying a little bit later. But the beginning of sort of copyright as a concept, even in intellectual property, starts obviously before the founding of America. In England, the mother country, we have sort of the kernel, the basic idea of a copyright first appearing in the 1500s. And this was a royal decree, but the rights were granted not to authors of works, but to the publishing companies, if you will, the stationers, the people who were actually in charge of making the books and selling the books. And these laws were to control the printing and sale of books. These were sort of royal grants that were given to denizens and partisans and patrons of the royal, for royal favor. And then I'd say around 1710, we start to see semblance of what might be a modern copyright law. This is the Statute of Anne. And this law allows, for the first time, the authors, not the actual stationers, to have or control the rights to what it is that's being produced. It still curiously required you to send a copy of what it is you wish to be protected under copyright to the Royal Library. Great way to build up your archives. Incidentally, if you were to copyright, if you want to register your copyright today, the Library of Congress still requires you to send a copy of your work to them. So even our own Library of Congress is, has a vast collection, in part because of this requirement to send a copy of that which you'd like to protect. But I think an important concept here, when we look back at the history, is copyright sort of started by the sovereigns kind of granting favors to certain people that they wanted to have these monopolies on. It was a very effective way of controlling what could be said, let's say, about your rule of the country, because if someone were printing something incendiary or something not very flattering, you would of course not give them one of these monopolies, not dole out one of these grants for these. So it was a very effective way of kind of censoring and controlling that which could be said. Now let's go back to the future. So 1789, the Constitution in the United States, even in the first article, way up at the top, Section 8, Clause 8, we have this innocuous sentence: to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. And it's this seemingly innocuous, simple sentence that births all of the IP laws in our country. So you can see that it was very much at the forefront of what our founding fathers were thinking when they were getting the country up and running after winning the revolution, in part because they understood the importance of what intellectual property means, both to sort of the economics and of the country, as well as perhaps to later society and artistic efforts. So the challenge, I think what makes intellectual property fascinating is there is never really any black and white. It's always shades of gray. So, we understand, or we study these things. You can argue, why does it all matter? I think it's interesting because we're constantly, as a society, trying to set a fulcrum point for intellectual property, something that sort of just strikes the right balance for protection for individuals in order to maybe incentivize them to create and to be innovative, but also not at the expense of taking away sort of the public or the commons rights. You can imagine, this is not an easy thing to do. And the pendulum will often swing one side or the other, with lots of variables affecting the outcome, even all the way things like the current economic climate, which particular administration happens to be in power in Washington, as well as sort of court decisions from the highest level all the way down to the district level. So this sort of fulcrum setting turns out to be really, really a difficult thing to do. And that's what I think makes it such a rich subject for for, looking into and evaluating. Why does this matter to you? Well, suppose you wanted to post a video on YouTube of you singing to your favorite song. There's intellectual property in that song, and you wanting to just simply post a TikTok video of you mimicking it, are you allowed to do that? Are you going to hear from the artist's attorneys because you've posted that video? Is it going to matter on how many hits that video gets? If you happen to have a picture in the background by some other artist, or in the window near your TikTok video, a FedEx truck drives by and their brand is somehow in do you have to, take that video out? Do you have to blur the FedEx symbol out of your video or not? These things matter. And, understanding which way the laws are leaning will affect essentially what becomes the rights of those individuals or corporations versus the rights of sort of you versus the rights of the public. As in, we like to watch fun and cool TikTok videos and not have lawyers kind of, coming down on us constantly. So let's talk a little bit about the philosophical underpinnings of copyright. In the very beginning, we have, there was the word. Just like in theology, there's special meaning, almost a holiness ascribed to the word. Think of the Bible, right? It's magic, it's divine. And the early thoughts about copyright, you can almost argue, were kind of seen reflective of this. For someone to create a work, it was seen as a very personal thing. You had mastery over that which you produced yourself, because just like the bond between a mother and child, this work of authorship sort of came out of you. And so here we have this quote from the 16th century that kind of equates the author of a book to being, God, and having God's plan, talked about in scripture. And that's kind of how we can almost generalize some of the early thinking about copyright. Was you don't get between the author and their work, because that's sort of like getting between the mother and the child. But that philosophy changes, particularly as we start to move away from the individual right, the moral right, the sacred right, to a utilitarian right. So this person's philosophy, this is John Locke, had a lot to do with the utilitarian view of property. Utilitarian view, for those of you Star Trek geeks, is the needs of the many outweigh the needs of the few or the one, right? So Locke basically thought, okay, when it comes to property, sweat of the brow kind of matters. What we mean by sweat of the brow is the amount of work that you directly put into something is perhaps proportional to that which you are allowed to take possession of through that work. So for Locke, if you come across a barren field, remember, this is the time where the new world is in play, and people are migrating over, and they're finding land that is perhaps never been made useful, and you spend the time till the soil, clear the trees, you raise a farm, it's producing fruits and vegetables and livestock. That work that you did, Locke would argue, allows you to have a property right in it, because it essentially was yours. And that's the same kind of philosophy that is applied to intellectual property which is not necessarily physical, but perhaps no less is tangible, even though it comes out of ideas or it comes out of sort of things that you develop conceptually. So the idea that consumes you, you bring that novel into the world. The art that sort of envelopes you creates that photograph, and your expression of that, which we feel perhaps could be, unique, is what allows you to have ownership of that. But now we start to see a little bit of a changing of the guard, because we're approaching sort of a utilitarian view of society in the sort of 17th and 18th century. And this is now where perhaps it's not so much the individual that matters, but what matters is the individual's sort of relationship to the greater whole. And so we see a sort of shifting in intellectual property, where now the benefit for protecting intellectual property is not so much because we think authors ought to have rights, just like the mother and child bond, but because society, we, the collective common, benefit when there are works of authorship. In other words, there are books that we like to read. There's commerce, there's industries that are popping up that rely on these things. And so we want to protect and incentivize people to become authors and painters and map makers because we benefit as a society collectively. And this is sort of the utilitarian view that starts to take hold. And this is essentially echoed in the Constitution in terms of the reason why we have IP laws is not just for the individual, but to promote science and the useful arts, AKA industry. And it's for this reason that things that have a sort of utilitarian purpose are some of the earliest things that are specifically called out in copyright laws, like maps and charts. So we see a de-emphasis on the moral rights of the individual, but it's sort of a gaining of the social right of copyright. And remember, it must be social because by its very nature, copying is a social activity. It takes two to tango. If you were in grade school and you didn't study for your quiz and you needed to sort of peek at the person next to you's answer, you needed that other person there to peek over their shoulder and see what they wrote down for their answers. If there's no other person, there's no copying. So the right in making a copy by its very nature is sort of a social thing. And this is what we kind of see happening. So the earliest copyrights, as I mentioned, are maps and charts. Think about the time frame that we're kind of talking about here, the age of exploration. There's a new world to be settled. And if you are coming over from Europe and you want to sort of explore the river estuaries and avoid, this tree-eating bear over here in the top left, it might be helpful to have this map when your ship arrives in harbor. So, valuable copyrighted works, sort of the satellite imaging of its day became, charts and maps. So cartographers are some of the first early adopters of copyright law. All right, so that's a little bit of the history and philosophical underpinnings. Let's start talking about the legal nuts and bolts. All right, so let's give you guys a definition. Copyright subsists, that is to say, exists in any original work of authorship fixed in a tangible medium of expression. Let's treat this as an equation. We're at MIT, we're comfortable with equations, right? If you ever wonder whether or not something is copyright protected, we will apply this definition, which has three parts to it. And if all three parts apply, then our equation is satisfied and we know that we have a copyright. So copyright exists in an original, that's one, work of authorship, that's two, that is fixed in a tangible medium of expression, that's three. So original, work of authorship, fixed in a tangible medium of expression. If you like, this is something you can commit to memory. If you ever have a question as to whether something could be protected under copyright, pull out this equation, recite this definition, and see if you can convince yourself that, the sets 1, 2, and 3 are satisfied. Okay, we'll get back to all of these in a second and unpack what original work of authorship and mediums are. But let's skip ahead to, let's suppose we have a copyright. Big deal, so what? What does a copyright get us? Well, Congress says that there are exclusive rights that copyright holders enjoy. These include the rights to reproduce, AKA to copy. It is the copyright after all. So if you wish to make a copy of your work, and I mean copy in the most literal sense, literally to reproduce it, and you and only you have the right to do that. If someone else were to make a copy without your permission, without a license, they would be infringing your copyright. Hence, lots of accusations of copying on the internet and sort of social media and things which allow you to make and distribute copies very quickly and easily at the click of a button, literally. Another right that you have is to prepare a derivative work, that is to make a new copyright that is based on or derived from the original work. And a great example of this is if you write a novel and then you wish to make that novel into a motion picture, a movie, then the movie is a derivative work of that novel, of that book. And in order to bring that story to the big screen, you are going to need to make sure that the owners of the novel copyright are on board and have sanctioned that movie. In other words, you've secured the rights. Another derivative could be a sequel to a movie, right? So you make a movie and then you make the sequels to the movie. Each of those are derivative works. There are lots of examples of derivative works that we can get into. You also have the right as a copyright holder to distribute, that is to say, to actually in commerce, sale, rent, or transfer that work to the others. And that's a very important right, because that's how money is made. And what we'll see in most things intellectual property, it usually has some kind of underlying basis in economics and finance. So making money obviously is a huge component of why intellectual property exists. You also have the rights to perform or display publicly, and we'll get into why those matter, particularly if you're creating paintings and artwork, or a dance performer. The being able to perform or display publicly is certainly something you want to protect. The duration of a copyright is a very, very long time. Right now, the life of the author plus an additional 70 years is the term of copyright. So it's an extremely long amount of time. Let's keep going. So again, the term is a very long amount of time. If you happen to write a novel today, and then let's say on your way out of your house later on, you got hit by a bus, unfortunately, tragically, your copyright in that book that you wrote would not expire to the year 2092, just to give you some sense of how long copyright would last. And that's, of course, if you met your tragic demise today. If you lived a long and healthy life, you would add all of those years onto that date of 2092. So you can see that the term of a copyright is much longer than the term of a patent, which is only 20 years, by the way. And there's some interesting historical factoids about perhaps why those dates kept expanding and growing. Incidentally, for corporate works like MIT's copyrights, works made for hire, when you are hiring someone to do a work, anonymous works like books that are penned under pseudonyms, then you don't necessarily have the death of a person, because we're dealing with corporations or anonymous folks. Then a different clock applies. First to apply 95 years or 120 years from creation. So 95 years from its publication. Not every work needs to be published, of course. So the clock would expire after 120 years from creation. And again, what essentially expanded these years of late was a piece of legislation in the late 90s called the Sonny Bono Copyright Term Extension Act. Some people kind of attribute it to Disney's lobbying of Congress to extend copyrights for fear of Steamboat Willie coming out of copyright. So they call it the Mickey Mouse Act, but effectively added 20 more years of life to all copyrights. So what used to be life of the author plus 50, 75 years from pub, and 100 years from creation, all each got 20 extra years of life, which means, if you're paying attention, that nothing really has entered into the public domain from 1998 to the year 2018. Because if you were about to come out of copyright, you immediately got an extra 20-year addition. So works have started to trickle into the public domain as of 2019, some movies by Charlie Chaplin, for example, and other things. So generally speaking, if the work was produced before 1926, maybe now 1927, it's kind of safe to assume it is in the public domain. But there is sort of a formula for calculating whether or not a work that is kind of aging is or is not in the public domain. So let's talk a little bit about some other facts about copyrights that are commonly misrepresented. The rights in a copyright are created when you create the copyright. That is to say, upon fixation in a tangible medium, you have a copyright. You do not need a C with a circle around it. You do not need to register your copyright with the Copyright Office. This is very different from a patent, where you do not have a patent until the USPTO formally issues you a patent and says you satisfied all the requirements. Now here is your patent. For a copyright, it's much more informal, and anything that you're doing sort of on the side will count as a copyright. You are allowed to register your copyright. In fact, you are required to register your copyright if you wish to sue someone in a US court for copyright infringement. But aside from that, there is no formal registration requirement. And if you are interested in registering your copyright, you fill out a fairly cheap fee, cheap compared to patenting, of course. And there are applications at the Library of Congress, which manages the Copyright Office. And you follow those steps and you will have a registered copyright. Now, there is a notice that you can affix to your copyright. I've given you a sample right here on the slide. It's usually the word copyright and the year that the work was either created or published. The name of the copyright holder could be your name or the name of the company. And then usually something along the lines of all rights reserved, if that is what you wish to let others know. There are other variants of all rights reserved, which we'll get to towards the back end of the presentation. And now let's talk a little bit about what are works of authorship. Works of authorship are meant to be pretty inclusive. These categories have been expanded over time by Congress. But what I want you to understand is that, when you look at these definitions, they are really meant to be inclusive, not exclusive. So if you happen to be taking notes during this presentation, you are effectively creating a copyright because you are writing something down that is essentially original to you, fixing it in some medium, perhaps, pen to paper, perhaps notes in your laptop if you're typing them. But in any event, they really are copyright protected, just as we've been talking about. And so works of authorship, literature, we don't mean just fancy literature like Shakespeare, but literally things that can be written down, like those notes that you might be taking about this presentation. Musical works, and what we mean by music, we mean both sort of the composition of the music as well as the lyrics. So there's layers of copyright when it comes to musical works. There's also copyright in the sound recording when a composition is brought into the studio and performed by a performing artist, which we'll get to a little bit later. The dramatic works, so works of the theater, plays, things of that sort are all protected under copyright. Pantomimes and choreographic works, so dance steps, are protected. Pictorial, graphic, and sculptural works. Number 5 is really meant to encompass the entire world of art. So whether you're taking a photograph, whether you are painting watercolors onto a canvas, whether you're doing modern art, all of those things are protected under number 5 as art, as a copyright. Movies, of course, audiovisual works, sound recordings, as I mentioned before, like an artist that's performing a song to tape to a CD or distribute and broadcast digitally, and even architectural works. What we mean by architectural works include both the blueprints of a building as well as kind of the look and feel of the building. So those of you on MIT's campus are familiar with the Stata Center, and you know that that's a Frank Gehry building, famous architect, and it looks pretty interesting because there's not a lot of straight lines in any Frank Gehry work. And so that work of his, that architectural work, is certainly his copyright protected design. Curiously, things that are not protected under copyright, and this list is important, include facts, ideas, titles and short sort of phrases, procedures, processes, methods of operation, concepts, principles, sort of discoveries, scientific facts, and functional items. Any work of the United States government by rule is in the public domain. So any sort of report that's put out by a government agency is in the public domain and not protected under copyright. But we're going to come back to some of these concepts, particularly facts and ideas, because the reason why facts and ideas are not protected is because, well, first off, a fact is not something that is an expression or original. It's a fact. So the date of today is not something that I can claim as my expression and prevent someone else from ever, using or printing or talking about. So it makes sense that facts about the world are freely tradable and freely shareable and freely expressible without any one person accusing the other of infringement. We'll unpack some of these other ones later on, but titles, why are titles not copyright protected? Here are some books about the 16th president of the United States, Abraham Lincoln. The first person to potentially write a biography of Abraham Lincoln might wish to call that book Abraham Lincoln. Does that mean that anyone else after that ever writes autobiography about Abraham Lincoln would be prevented from calling their book Abraham Lincoln or some variant thereof? No, of course not. That would be silly. So titles are not copyright protected because the title in and of itself is a short, phrase or, not really an expression. And so we can see evidence here that all of these authors are allowed to call their book essentially Lincoln because that is the subject of their piece. And it would be silly for them to have to try and invent new ways of titling their book, like the 16th president of the United States or the guy who got shot in Ford's Theater. No, you can just call your book Abraham Lincoln and be done with it. So titles are not protected under copyright. You'll see examples of those sometimes where movies share titles or books and movies share titles. It could be a little confusing sometimes, but the trade-off is worth it. All right, let's talk a little bit about who owns a copyright ownership. Right now, and if you are the sole creator of a work, then you are the sole author of a work. So the author of the work is the default owner of the copyright. Now this gets subject to any employment agreement that you might have. So if you work for a company and you sign something on day one that says, any copyrights or any intellectual property you produce becomes the sort of property of your employer, particularly in the act of creating them for employment, then of course, then the company is going to own those copyrights. If you are a freelance photographer and you enter into a work for hire relationship with a paper who will purchase your photographs to print them in their publication, then of course you are often turning over the copyrights in those photographs to them. So work for hire agreements, employment agreements, any sort of assignment obligations that you might be subject to are going to always transfer ownership away, even though you potentially were the author of the work. There's also the ability to have a jointly owned copyright. And that is when there's the intention for two or more folks to collaborate on a work of authorship. And the intention is to kind of have those works fused into an inseparable whole. So it's not so much that I'm going to write, pages 1 through 5 and my colleague is going to write the rest of the book, but I only have sort of a copyright on pages 1 through 5 and they only have a copyright on the rest of the book. No, our intention is to kind of contribute and collaborate and discuss ideas freely to create this work. And both of our names are going on the cover as authors and we both own the copyright to it. And each person having essentially an undivided 100% interest in the work as a whole. Now, that being said, there are situations where you can have piecewise by contributor obligations. If you think of perhaps some kind of publication that posts different journal articles or different contributions that are not necessarily organized to be the same book, but they each kind of talk about a subject, but are still the work of the individual contributor. Or you might picture a software program that's being built piecewise, like an open source contribution, where each person is bringing a module in or adding a component. Well, then you actually do have the ability to have those sections, those layers owned by those individual contributors. So it's going to depend on how you set up the work. I have a picture here of Naruto. Naruto was an interesting test case to who owns a copyright fairly recently, because this macaw ape happened to snap a picture of himself, as you can see here, by coming over to a photographer's rig that was set up to take photographs of this park. And while the photographer was away attending to some other business, Naruto came over here and found the button to take a picture and snapped an awfully good selfie. And so good that people wanted to purchase Naruto's image. And the photographer assumed that that was his intellectual property because he was the photographer and he owned the camera and he set it up. And yes, it so happened that he walked away to do something else when the Naruto came over here to push the button. But why does that matter? Well, it matters because the person who pushes the button behind the camera is generally considered to be the creator of the work. In this case, Naruto. Can Naruto own a copyright in his own photo? It turns out that that question plagued our courts for the better part of a decade and was answered fairly recently after many appeals definitively to say, unfortunately for Naruto, our laws are built to set up to address people and not animals. So even though the photographer, that does not mean that the photographer gets the rights in the photograph either. It more means that there was no copyright in this photograph because Naruto was prevented from owning the copyright, being the fact that he is a non-person or non-human. So, all right, let's talk about originality. So we have works of authorship. Now we have to find out what is an original work. So the law is that only a modicum of originality is required. This comes out of the Feist case. The Feist case is a fun little story. I'll sort of describe it quite briefly. There was a rural telephone service, I believe in Kansas, that went around and collected a list of all of the townspeople that subscribed to its telephone service. So you can think of this as the early white pages. And so they knocked on door to door and got folks' last name, first name, and their telephone number, and they would publish this list for the benefit of the townspeople who might need to call their neighbors. Along comes Feist, which is a larger company that puts together sort of bigger white pages, not just of local towns, but more regional geographic areas. And as such, then can reach out to more advertising folks because people that are not just subject to the town, perhaps to the city or to a larger geographic region, opens up the door for more advertising dollars. So Feist wanted to use rural telephone services directory and they asked for permission, which permission was denied. They then just took the book anyway and republished it in their larger directory, which prompted a suit by rural claiming copyright infringement. They did not give permission and they did not want their subscribers published in Feist's publication. The case goes up to the Supreme Court and rural telephone company or its attorneys make a lot of arguments along the lines of the sweat of the brow doctrine, remember from John Locke, and they said this was our work. We went around and collected this data painstakingly, and Feist, who just comes in without doing a single thing, without breaking a single bead of sweat, should not just lift this publication and put it in theirs, especially when we did not give them permission. Pretty convincing argument. However, unpersuasive. They actually lose the case. The reason why they lose the case is because the judge essentially looks at what the information that was taken and sees last name, first name, town and telephone number. Now to this judge, this seems awfully like a very routine or rote list of subscriber data. In other words, if you were going to collect a database of information about your subscribers, you would likely organize it by name and telephone number. And so to this judge, what is essentially being created is a sort of long list of facts, but certainly not any creative expression, no originality. And so because there was not enough originality to warrant an original work of authorship, rural telephone services list was deemed really not a copyrighted work. And if it's not a copyrighted work, then Feist was not infringing that copyright by republishing it. And what the judge essentially said was, although novelty and importance are not really what matters for originality, you really do have to have some expression that means original to the author. And the vast majority of works will qualify, even if they're crude, rude, humble, or obvious. But a directory listing of just last name and telephone number is too fact-like to be protected as copyright. It'd be the equivalent of writing down the temperatures of each day of the year and claiming that that is a copyrighted work. Now, before you kind of think about that one more carefully, you might argue, well, isn't that exactly what an almanac does? An almanac will show a lot of facts and figures about the weather over time. And isn't an almanac copyright protected? It is, but we're going to tell you what's the distinction there. The key concept that we get out of this is facts are never protected. So you can sort of go into an almanac and pull out whatever the temperature was in Boston in the year 1947 on January 14th. that's not a protectable expression. But the way the almanac perhaps organized all of its data and all of the facts and figures and all of the artwork as a whole, as a compilation, is what actually gets protected. So rural doesn't get a copyright on, last name, first name, telephone number, but had it perhaps did something slightly different and slightly even more creative, it may have been enough to get over the originality hurdle. So maybe, last name, first name, favorite rock band, telephone number would have been viewed differently, but because they just kept it very simple and fact-like, they lose. So we learn that there is a small hurdle to make a work original. And what matters is not, again, that it's sophisticated or important, but the fact that it wasn't copied from someone and it represents an expression that is unique to the person creating the work. So facts aren't protected. Compilations of facts might be protected. So yellow pages and almanacs have an original collection of information. And if you look at those collections as a whole, that's what's being protected, even if any particular granular fact that you might lift out of those repositories is not protected under copyright. So this opens the question, what do we do with regards to data? Because data lives in this kind of, fuzzy, space of being both very granular, but also very important thematically when you kind of extrapolate out. And so is data protected under copyright? So let's look at like a very simple SQL chart here that just has a list of names of columns and certain pieces of data. Is this protected under copyright, or is this more like last name, first name, town, and telephone number? What about this kind of a database schema? This clearly seems like it's structured in a higher sophisticated way than the SQL table. There's a lot more information. The connections between those tables look like there's a lot more going on too. And so would this database be more protected than a simple SQL chart? The answer, of course, is going to be, it depends. I would certainly bet more on something like this schema being protected under copyright than this simple chart. But ultimately, the question as to whether it is or is not is often left up to a court or a judge to decide, usually from a suit being brought. And it's for that reason that data is sometimes not even handled as copyrighted information at all. So it might be protected under copyright, but it also might not be, as FICE taught us. So when data producers or data subscribers will often treat their data slightly differently. They might protect it as trade secret, which is to say they will keep all of their data behind a firewall and not let folks have access to it. That makes the question of whether it's copyright protected moot, because they can rely on it as privatized business information. They could also rely on it if they are the producer of the data as just any property that they produce, subject to a type of data transfer agreement or data use agreement. This becomes no different than any other property or proprietary information that you might hold. And so a data use agreement or something like that kind of eschews whether it's copyright protected. It doesn't rely on copyright in order to work. It's just, I have this thing. If you'd like to use this thing, here are the terms we'll mutually agree to govern this contract. So it becomes contract law, not necessarily copyright law. Data, of course, being so vital for training artificial intelligence and machine learning models, really we're seeing an increase in importance of data and its implications. So this remains a very hot subject that we've had some other IAP sessions on and continue to explore. Data comes in a myriad of forms. The sort of provenance of how data sort of moves in and out is very complicated, and ownership may not be clear. There's often lots of strings attached. There could be regulatory or private information if you're dealing with medical data, for example, patient data for training machine learning health models. So the question about how data is used in this is itself warrants its own exploration and subject. Let me give you a quick digression into software code. So machine code, as you may know, is simply the sort of zeros and ones, the binaries that an operating system executes on. Think of the Matrix, that scene towards the end where Neo is seeing everything in the Matrix as sort of the machine code that it is. It's very hard to operate in machine code. It's very hard to write and debug in machine code. Show me where in this picture is the pattern of ones and zeros off that's making my program not function, right? Virtually impossible. So programmers will use source code. Source code, of course, is a sort of abstracted language that gets compiled into machine code, and source code is much more readily available for us to sort of create and use and debug. Here's an example of some source code on the screen right now. And I guess a question that I'm going to ask you guys is, we know that literature is protected, right? The works of Shakespeare or any novel that gets created. What about source code? Is source code in literature the same? Well, let's apply our equation. Is this an original work of authorship fixed in a tangible medium of expression? Is it original? I would certainly argue that source code is original. You give 5 programmers requirements, they'll come up with 5 different ways of programming those requirements. They're not going to all latch onto the same lines of code. So is it a work of authorship? I would argue, maybe we'll save that one for last. Is it fixed in a tangible medium of expression? Yes, you can see it right here in front of you. You can print it out on paper, just like you can the essay. It can live in your laptop's hard drive, or on a thumb drive, or even in cache memory. So certainly fixed in a tangible medium of expression. It turns out this question was answered by Congress in around 1980. They specifically amended the Copyright Act to include computer programs. Computer programs fit into the literary works, number 1 under works of authorship, whether object code or source code, and they are protected from unauthorized copying. And so the question about whether software is an actual copyright has been settled for all. It is. These two are essentially equivalent, and programming is considered no different than music or movies when it comes to copyright protection. Let's talk about mediums of expression. What we mean by mediums, we mean both tangible mediums. Think of traditional media like paper or canvas if you are a painter, and other types of materials, but also non-traditional media. So machines, databases, servers, networks, RAMs and ROMs also count for fixation. Even if that fixation is fleeting, like in a cache memory that gets erased, it still counts for fixation. And so electronic media count just as much as sort of old-fashioned media for mediums of expression. And in one of the sort of rare instances where Congress was very sort of forward-looking, they included in the statute that media means things that are both now known or later developed. Anything that will effectively facilitate perception, reproduction, or communication of the work, whether directly or with the aid of a machine or device. So they kind of made this future-proof. So as technology advances and we get new and new types of media, copyright law will sort of adapt, and media will, copyrights will apply to those new media as a result of this expression. All right, let's talk a little bit about an idea and the expression of that idea and some of the problems we get when we really think about those two concepts overlapping. And I like to illustrate this with this picture here. So this picture represents a bike rack. You've probably seen them around. There might even be some on campus. My question to you as a thought experiment is this bike rack copyright protectable or not? What I mean by that is if we were to sort of take away the bicycles, you can also argue that this sort of iron or metal structure of up and down, almost sine wave-like structures could just be a modern piece of art. Take the bikes away, and what you get is this wavy bar. Could a wavy bar be copyright protected? What if that wavy bar was my piece of modern art that I wanted to, display on campus? We would argue that that is copyright protected under art. What about when I then have students come over and say, hey, this is great, I'm going to lock my bike to it, thanks a lot. Does it still become copyright protected? Because didn't we say earlier that things that are functional cannot be copyright protected? And doesn't this now have a function as serving as a bike rack? And shouldn't a bike rack that's functional kind of be best left up to the patent office to decide if this is patentable or not as a bike rack? So this brings up what we call the idea expression dichotomy. Ideas, we've said, are never protected, only their expression of the idea. And so this represents an interesting test case. If expression is what counts, then there are going to be these situations where the idea and its expression kind of fuse, right? So where along the lines here is it art, and where along the lines is it a functional bike rack? Can you point to any particular part? Not really. I can lock my bike up here. I can lock a bike up here. I can put a bike lock here. I can put a bike lock here. I can put a bike lock here. There really is no piece of real estate on this where I can point to say one is art and one is functional. And when you have this kind of fusing of the idea and its expression, what you basically get is this dichotomy. And unfortunately, in those situations, copyright cannot apply. So you lose copyright protection altogether. This is what we call a merger. Merger is when the idea or the concept and its expression fuse. There's a couple of other good examples if this one's confusing. A recipe, how-to, right? If you want to talk about baking a cake, there's not a lot of ways to really describe it, right? You crack a few eggs, you mix in the batter, you put it in the oven at 350 degrees for 20 to 30 minutes, and voila, you have a cake. That sort of expression is not really ownable by one person. First person to write that down should not force the entire world to figure out a different way of how to describe baking a cake. That would be kind of extra work that's unnecessary. So in that situation, the sort of simple how-to, the simple steps of cooking something kind of remove its ability to be expressible under copyright, its expression. And it just becomes kind of a simple way, a simple how-to of describing something. Sweepstakes, the first person to ever say, send in a self-addressed stamped envelope if you want to win the prize, was deemed in court to be subject to merger, so that we didn't have to have other companies that might want to do sweepstakes figure out extravagant or circumlocution to express something that we feel is very simple. So so that is what happens there. Let's talk a little bit about when things go south. What happens when there's accusations of infringement? What are the limitations and what are the remedies? In order to have infringement of a copyright, you need to have access to that copyright, and your work has to be what's called substantially or substantively similar. So it requires two elements. One, access to the original work. Remember, you can't copy if you were not exposed to the original work, just like you can't copy off the quiz in grade school if you cannot see the other person's answer paper. So access is fundamental. If you can prove that there was no access to the other work, you can essentially win your infringement case because there's no need to move any on to step two. But if there is access, or if you can assume access, then you must show that the two works are substantively similar in order to prove that you've infringed them. There are some exceptions to this. Independent creation is allowed. No access means no copying. A judge famously said that if two hermits living in caves on opposite ends of the work wrote the same poem, they would each have copyrights in their poem because they wrote them without access to the other. No access means no copy. So think about that. Identical poems, but each are owned by those independent authors because they can prove in this thought experiment no copying because they lived in a cave on opposite ends of the earth. Right now, we don't live in caves for the most part. And so with information flying around and with sort of media being ever present, you can sometimes assume access. A song that played on the radio, you might say, arguably, affects everybody. Books and literature that are circulating around, even if you cannot find a photograph of your infringer looking at it or listening to it, doesn't necessarily mean that they did not have access. That's okay though. De minimis copying is still allowed. Meager, insignificant, sort of trifling bits are accepted, and this kind of gets into fair use, which we'll talk about in a second. But just know that unconscious copying is not a defense. So if you're a software developer or even a musician, you could still be found guilty of infringement of a work if you even inadvertently used it without knowingly. George Harrison was a Beatle, and he wrote a very famous song called My Sweet Lord, which some people accused of being very close to the Chiffons' He's So Fine, a Motown hit from 10 or 20 years before. And because the melodies were essentially ruled similar, and because the Chiffons hit was a #1 hit that played around the world, George Harrison was found guilty of copying, even though he's a Beatle, a musician of, utmost importance in his own right. And the judge didn't think that George did it on purpose. Nonetheless, he was still found guilty of copying because the elements of the case were there. I want to make a quick note in an academic environment, we're often talking about copyright infringement and plagiarism. These are not equated concepts. Plagiarism is often an academic infraction, whereas copyright infringement is a legal infraction. You're taking property without a license or without permission, not borrowing ideas without giving attribution. Put another way, you cannot get out of a copyright court case simply by citing where you stole or copied your work from. Yes, Your Honor, I did copy Dan Brown's The Da Vinci Code, but I certainly cited him in all of the instances where I put it up online. So it's not copying. No, you would lose that case. So plagiarism and copyright infringement are not the same thing. So this begs the question, when we're talking about copyrights, how do we actually make any sense of copyright infringement cases? Because most of the time, the copying is not going to be a verbatim. It's not going to be a direct or literal copy. You're not going to take Dan Brown, or you're not going to take Harry Potter and reproduce it and then pass it off as your own. But you might do something that is really similar, just sort of flirting with that line of borrowing just a little bit too much. And so that becomes the question: when is borrowing, when is being sort of inspired, or when is sort of borrowing go a little bit too far? And this is the situation we have for what's called non-literal infringement cases. And in these situations, it's unclear because there's, again, not a black or white line. And so what you do is you have to kind of get into the shades of gray and see where you might net out. You try your best to look at something that is inherently subjective, but you do so using what we hope is an objective process, and see how that nets out. And so there's this abstraction filtration comparison test that's been developed to help sort of essentially guide our thinking when we're looking at two independent works to see if they've borrowed from each other. And the way it generally works is you kind of break down the works into these levels of abstraction. Think of them as kind of high level and low level. And then from each level, you filter out things that are kind of what are called senza faire, stock characters, common elements, things that are going to be sort of present no matter what in any of the works. If you're writing a story about wizards, teenage wizards, you're not inherently infringing Harry Potter just because you're writing a story about a wizard. J.K. Rowling, of course, doesn't own the genre. You're free to write a story about, wizards, and there are going to be certain things in those stories that you need to also use, like, broomsticks and, witch handles and black cats and magic potions. The fact that all of those elements are in both stories doesn't, in a sense, prove beyond a shadow of a doubt that there's infringement, because those common elements and those stock characters, you could almost think of them as public domain. And each story is going to have their sort of thematic common elements or stock characters. So you got to filter those out. And then what you kind of look at is you try and compare whether or not there's still substantive similarity after you've done these abstractions and filtrations. So, you're allowed to write a story about teenage wizards, but, if you call your character Barry Porter and he goes to, Logwarts to be trained, now you can kind of argue, okay, this is, filtering out all the unprotectable elements. You're still kind of borrowing a little, you're trading a little bit too closely to the original work. So that's going to be found guilty of infringement, right? That's kind of the idea. So when it comes to software, you also have to factor in elements dictated by the public domain, elements dictated by efficiency, and external factors. If you're writing a program in sort of Unix, there are going to be certain commands and certain parts of your code that you have to sort of use in order for the computer program to operate or to understand what sort of environment it's going to be compiling in. So none of those things count as far as expression when you're trying to determine whether or not someone's infringing. So let's look at a quick test case. Here I have two posters on the screen, and your task out there is to tell me whether or not the Moscow on the Hudson Robin Williams movie poster is infringing the famous Saul Steinberg's New Yorker cover, right? The New Yorker cover comes out first. It's kind of a famous now artistic expression about a myopic view of a New Yorker to the rest of the world. You hopefully get the joke. New York is very much in focus, the center of attention. There's lots of detail. The buildings are prominent, but the rest of the world outside of New York is effectively a carpet with a couple of bumps, right? And that extends all the way across the ocean, looking across into other countries. So you get the joke. Now, what the Moscow on the Hudson movie poster tried to do some years later was maybe borrow some of those thematic elements. Of course, there's a story of someone who's trying to defect to the United States from Soviet Russia. And so very much New York and the Soviet Union play into the story. So we here have a scene of New York, again, featured prominently, and then perhaps some other elements that are not so prominent, like London and Paris, and I'm not sure why they have a Leaning Tower of Pisa in Rome, but and then Moscow, of course, is featured prominently in the foreground. So does this poster infringe the copyright of the New Yorker? And I guess if we apply our sort of levels of abstraction, no one is allowed to own a sort of caricature of New York. And so you can argue that this is not a literal copy of the New Yorker magazine. You can see there's skyscrapers in the New York City scene in the movie poster. The buildings are not identical, although there are some buildings that do look very similar, right? The first building on the right of the Broad Avenue there looks a lot like the first building on the left in the New Yorker magazine. So clearly the cars, and maybe even the width of the streets look like, there was certainly some borrowing going on. And to be perfectly honest, this is not a mystery. The movie poster was, you can argue, paying homage to Saul Steinberg's famous art cover of the New Yorker. So we get into this question, is homage in of itself copyright infringement? What if you're paying tribute to the artistic style? Are you allowed to do that? And of course, it's going to also rest on the question of how much are you borrowing? But again, it's not a literal copy, right? In the movie poster, we're looking across the Atlantic towards Europe. In the Saul Steinberg work, we're looking west across the Hudson and the Pacific towards Asia. So there are enough differences here. The question is, where do we net out when we do our levels of abstraction? It turns out that this particular case was decided as infringement of the original work. And in part, maybe because they borrowed just a little bit too much. If you look at the font in how Moscow on the Hudson is written, it clearly borrows the classic New Yorker font as well. The W in New and Moscow, for example, are identical. And so they just thought that perhaps there's a little too much borrowing going on if this were just sort of thematic or homage. So this was ruled an infringement, but it's always ever interesting to me to have these types of cases and to really think them through carefully. Do we want to live in a society where these things are decided as always infringement? Or do we want to live in a society where homage and sort of, being inspired by other artists to create new works, transformative works, is appreciated? And that's a great segment to our next topic, fair use. Because fair use is designed exactly to do that which I said, which is to allow society to be able to be influenced by thematic works and hopefully repurpose them, reuse them, and make them transformative into new works that will inspire new artists and create and benefit the public and society as a whole. So fair use is seen as a defense against any accusation of copyright infringement. And it's part of the Copyright Act that says, any copyrighted work will be considered used fairly if it's used for things like criticism, commenting, news reporting, teaching, scholarship, research. So the fact that I'm able to use these images in my talk to you, for the most part, is going to be protected under fair use, because we're doing so for, you can argue, metacritical discourse and teaching and education, certainly not for any kind of financial gain. But it's not always an open and shut case. And what they basically say is you can't assume fair use, but if you do want to understand if your work is fair use, there are 4 factors that should be considered: the purpose and character, the nature of the copyrighted work, the amount of what you've borrowed, and the effect on what you've done on the market for the original copyrighted work. And if you look at these 4 factors and then also pay a little bit of tribute to what they say in the first part, the preamble about, is it news, is it teaching, is it journalism, you should somehow figure out whether or not there is fair use. And an interesting case that kind of brought all this to the forefront was the Gerald Ford case, as I like to call it, Harper Row versus the Nation. For those of you who remember, Watergate was a pretty tumultuous time in our country's past. It kind of mirrors essentially what we're going through in many respects today politically. But Richard Nixon resigned ignobly because of the Watergate scandal. Gerald Ford takes over as the new president, as his vice president. And the first thing he does is he pardons Richard Nixon, which I think never allowed the country to really heal its scar. So Gerald Ford, finishes his time as president, and all presidents do. They write a memoir of their time as president. And Gerald Ford's memoir is about to hit the shelves as a book when a magazine called The Nation, perhaps attributable to a little bit of dumpster diving, gets an advanced copy of the chapter on Watergate and publishes it, scoops them on the eve of the book being published, and just republishes the Watergate chapter in its magazine. So clearly that's, a huge, huge story. And so the publisher, Harper and Row, sues the magazine The Nation for copyright infringement. And The Nation essentially uses fair use as its shield against this claim and says, no, we did everything that fair use allows us to do. He's a public figure. He's in the news. Our work is a work of nonfiction, and we only used a little bit, less than 1% of the whole memoir is what we reproduced in our magazine. Nonetheless, the courts found all of those arguments non-persuasive and just relied on the 4th factor, the sort of use of the potential market, this 4th one here, and said, unfortunately, you picked the most interesting part of Gerald Ford's memoir because, pardon the expression, but he was so boring, nobody really cared about his presidency. All they wanted to read was the chapter on Watergate, and that's the part that you stole. So they lost this case simply on sort of gutting the market for that book by publishing that chapter without permission, without a license. So fair use is not a quantitative safe harbor. You don't just add up the checks and minuses and say, we're good, 3 are on our side, 1 is not on our side, we're going to win. No, it's really a qualitative exercise, and one factor might, overturn all of the other ones that might be in your favor. That being said, parody gets special consideration for fair use. If you parody something, it's seen as, a type of transformative use, and that seems to be what a lot of the courts are focusing in on now. Remedies for copyright infringement: if you are found to be infringing someone's copyright, the copyright holder stands to gain injunctive relief. They can destroy any copies of the other person's work. They can enjoin them, that is to stop them from creating or selling or manufacturing any new works. And then of course there are damages, money that you will win from the person who's guilty of the infringement. Now there's what's called statutory damages. I mentioned on a couple of slides ago that you don't really need to register your work unless you wanted to sue someone for copyright infringement. And here's where this comes into play, because if you are suing someone for copyright infringement and you've registered your work, you're entitled to what are called statutory damages. That means you don't need to prove through evidence your actual losses. You are just entitled to a sort of math formula of how much you can collect based on each infraction. And so it turns into sort of an arithmetic exercise of how much you can then collect, because you know how many times the work was infringed and what you're entitled to, and you just kind of multiply it through and you come up with a number. And these numbers can be quite substantial, up to $150,000 for each infraction if you are found to have willfully infringed, that is to say, infringed knowing intentionally that the work was copyright protected. And this is per infraction per sale. So you can quickly see how copyright damages can escalate into hundreds of thousands, if not millions of dollars in awardings for the original copyright holder. Of course, for very egregious types of infringements, there's even criminal prosecution. Criminal prosecution is usually reserved for people who are pirating copyrighted works. So if you've ever seen one of those scary messages with this sort of federal seal at the beginning of a movie back in the old VHS days when people actually watched movies on VHS, you don't see them as much on streaming anymore. But they, were very scary messages that said if you're illegally pirating this work, you can be subject to criminal prosecution by the FBI. And that's what they meant by that. All right, let's switch gears now and talk a little bit about another type of way that copyrights get transferred to the public, and that is through open source. This is particularly for software, but we're also going to see another category of other types of works that are not just software and how they get proliferated through something called Creative Commons. So the first kind of notion of open source happens at MIT in the 1970s. Richard Stallman sort of comes up with an idea that software ought to be free, not free as in it costs nothing. They often say free as in free speech, not as in free beer. And so the Free Software Foundation was about trying to open the doors of software development to those beyond your employ, right? So if you happen to be a company and you have hired a team of 3 software programmers, that's the extent of your development team. But couldn't you do much better if you kind of opened your source code to the world so that you literally had infinite a number of software designers, architects, and developers? Would that product not be better than just kind of keeping it, again, behind a proprietary wall? So that was the idea. And what they created essentially was a type of license. The first open source license was called the general public license. And what the general public license essentially said was, we're opening this code to anyone to freely look at it or change it, but you just have to agree that anything you do with it when you change it is kind of put back in to the playing field so that everyone else, whether upstream or downstream, gets to see your changes, gets to enjoy your changes. So that was the concept behind it. It's sometimes called copyleft, which is what this backward C in a circle is on the sort of upper right-hand side of the screen. The reason why it's called copyleft was because it's not public domain software. It still very much relies on the fact that copyright exists in order for it to function, because the general public license is in fact a license. And so a license by definition only makes sense. It gets its teeth from there being copyright in order to enforce that license. If it were public domain, nobody would have to listen to anybody and anyone could do whatever they want with it. That's the whole point of it being in the public domain. But because it's not in the public domain and it's subject to someone's property, but for the license, that person is creating a license under very freely permissive terms so that others can use them. But if you violate those sort of terms, if you essentially do not listen to the rules of engagement, you can still be sued for breach of contract and other things like that. So this is using sort of the idea of copyright against itself. Remember, copyright almost meaning stay away from my property unless I give you permission. This is saying to copyright, no, everybody please come join me on the lawn and play with my work. And the reason why I'm allowing you to do that is because I have the copyright to do so. So when you sort of use copyright against itself, we call this kind of copyleft. And there are certain licenses that are deemed copyleft, the general public license being one of them. The first thing you should understand is the general public license becomes kind of the initiator of what's called open source, but it by no means is the only open source license. Open source now has become a brand, and a license will be considered open source if it's managed and controlled by the Open Source Foundation. And they manage a sort of a list of dozens and dozens of license agreements, each of them all claiming to be open source licenses. So people will often use open source just to refer to, a type of license, but they're misusing the word. There could be many licenses that are open source, and each of them with their own strings attached. So you have to be careful about which open source license your particular might be subject to. Do not equate it with free software. Do not equate it with public domain software, because these are not the same concepts. And a license can be considered open source. What it means is that everyone understands the terms of the license a priori. And so they don't necessarily need to hire lawyers or other experts to read the fine print of the license agreement or contract, because these terms are sort of nailed to the church's outer door, and everyone can read them and know what they are and know what the implications are. That's sort of the concept behind open source. So let's look at a couple of popular open source licenses. I've picked sort of two polar opposites, just to give you a sense of, even within the open source world, how they can vary. This is called the MIT or BSD license. It's a very permissive license. You're looking at the entirety of the whole license. It's just, these 6 bullet points. And essentially what this license does is laid out right in front of us. It's not relinquishing copyright. So it says that the copyright notice is still very much in effect. The copyright year owner, all rights reserved. It then says that you can redistribute this code, whether in source, we talked about source code, or binary. Binary is machine learnable, the zeros and ones, with or without modification, provided you just kind of do what it says underneath. That you have to keep the copyright notice in. You're not giving up copyright notice. You're not putting it in the public domain. So the copyright will stay throughout all transmissions downstream, and that neither, in this case, that the organization that's providing it is not being used to endorse or promote any products derived from it, and that the software is essentially being provided as is. Meaning, if it doesn't work or if it doesn't quite do what you hoped it to do, you cannot come back and sue the copyright holder or anyone else upstream of you for this. It's sort of take it or leave it, use at your own risk. This is the entirety of the license. And what this license means is, as long as you keep the copyright notice, don't use the endorsement and treat it as is, you can do whatever you want with it. You can modify it, you can not modify it. You can put it into a proprietary code. You can make lots of money with it and never send a dime to anybody but yourself. You can forget it. So this license is kind of the Wild West. You can do whatever you want with it. Very permissive, very open. Throw it over the wall and I don't need to hear about it ever again. To contrast, the general public license that I talked about a little bit earlier is very different. This is just one snippet of the license. And what this license says, you can modify and copy the program or any portion of it and make this work the base of a new program, modify it. But when you do so, you must, any modified files must be prominently noticed that you've changed them. You have to sort of flag where you've changed them. You have to call to attention those changes. And even though you can license the work at no charge, you still have to essentially provide your source code. What you've changed has to be accompanied with directly embedded into the source code for the next person in line. So this is very different. This is saying if you want to play in the sandbox, you're going to agree to these rules. And if you don't, then you're in violation of this license. So if you want to modify this code or put it into a product, you're allowed to do so, but you're going to make sure that you call to attention everywhere that you've changed it, and you're going to have to put your source code up for the whole world to read, essentially open sourcing your proprietary code as a result by distributing it and modifying it. And you're also going to charge no cost for these changes. So this is, a very different license, both open source, and they both kind of serve different constituencies, right? Academics might have no problem agreeing to these terms because they would like their code and other, users, their source code to be publicly scrutinizable. Think of it almost like a public ledger, like blockchain. They want other people to see what they've done and maybe improve upon it. But if you're a company, this could be very bad for you. You don't want to risk infecting yourself and potentially opening up all your proprietary code that you are making money on. So the BSD license looks a lot better because in this one, you don't really have anyone to account to or answer to, right? So different licenses, different constituencies. And now I want to talk a little bit about Creative Commons. Creative Commons essentially allows you to do all of these things for different types of copyrighted works other than software. So Creative Commons essentially was, hey, let's figure out a way of bringing to the masses different types of works that are not software based. In other words, instead of all rights reserved, like the copyright notice says, what if we just wanted to reserve some rights and allow others to freely barter and trade with lots of other parts of our works? This is the license for you, because this has a menu, like an a la carte choice of options that says, I'm a copyright owner of a work, but I don't mind if certain constituencies do certain things with my work. I don't need to know about it. So this is one of those licenses. I've just taken a sample of a non-commercial use attribution license. So you're freely available to use this copyrighted work, provided that you're not making any sort of commercial use of it. So you're not directing it towards any commercial advantage or money compensation. And if you distribute the work, in the second paragraph, you must keep the copyright notice intact, the name of the original author, and a credit identifying sort of the work, giving attribution, such as, this was a French translation of the work by this original author, or this is from a screenplay based on the original author, so on and so forth. So you provide a link or you provide sort of the attribution, and as long as you're not doing anything commercial, you're freely allowed to use this work with ever not having to go back to the author for permission or license. So extremely, extremely valuable. And with the remaining time, let's talk a little bit about software patenting. Software patents do play a role in this story. Remember that copyright law is there to protect expression, but not functionality. Think of our bike rack. But a computer software is very unique in that it sometimes blurs the line between sort of expression and functionality, right? We have a very hard time trying to think about that blurring of the line for software patents. A big question is what exactly you're getting a patent on when it comes to software or algorithms. It's easy to think of a patent as covering the cotton gin. It's a mechanical invention, industrial revolution, you turn a crank kind of a thing. But what are you getting when you put a patent on an algorithm, right? Here, like this flow chart that just says there's information and other components going in and out, but there's no real tangible part of this. It's not mechanical, it's not a crank. So what exactly are you going to get a patent on if you're filing a patent on this sort of expression that is an algorithm? It almost feels a little too idea-like and difficult to give a monopoly on to one person for 20 years. And that's been kind of the fundamental challenge that plagues our courts. We're actually going through a period right now based on the Alice decision that talks about sort of how many software patents are being rejected because they blur this line of the idea versus sort of the system or the expression of the idea. And there have been some attempts to fix computer processes if they're tied to a machine or device, if they're transformative, if they add something more than just the abstract idea, which is the current sort of thinking for guidelines for getting over Alice types of rejections. But essentially, you have to understand that your software, your source and machine code might be covered by copyright, but that does not protect essentially the function of what your software is doing. So if you create a word processing program and you get a copyright on that word processing program, you can have a protection on your source code, but you will not stop others from creating other types of word processors. The functionality itself is not what's protected, just the code that you've written to do your specific expression. If you want to sort of protect against other types of word processors. It would be difficult to do, but if you wanted to sort of explore that, you'd have to really explore software patenting and try and get patents on the systemic or functional components of a word processor. Again, hard to do now because they're so ubiquitous. But software that is not protected by patent is always subject to what we call clean room creations, independent creations. You have an app and it does something interesting and cool, and then you're just protecting it under the software copyright. You cannot stop someone else from creating a competitive app that does something similar, provided they're not copying your code, right? If there's no access to your code and they're not doing something similar, then what they're basically doing is kind of independently creating or clean room coding something similar based on similar requirements or similar boundary conditions. There's nothing you can do to stop that unless you get a patent. So the functions or the application of those algorithms might be protected by patents, but those patents are controversial and they're increasingly being targeted for ineligibility under sort of Section 101 Alice types of rejections. But that's a story for another day and a different lecture. So with that, I'm going to end this chat and thank you all for listening in and tuning in. I don't think we may hopefully have time for a few questions, but any questions that I may not get to answer live, I will certainly do my best to respond via email and get back to you. So I'm going to turn it back over to Aiden, I believe, who's been monitoring the questions that have been coming in. Aiden, anything out there that you'd like to have me talk about?
Yeah. So one thing that came up a few times is how copyright and IP work in regards to NFTs.
Interesting. So, NFTs, non-fungible tokens, again, as a concept, as a technology, are likely not going to be protectable under or covered under software alone, right? So you have to think about, are there patents on, NFTs, on the concept of NFTs, just like are there patents on, public ledgers, like in blockchain? And, that's, again, going to be open up a very rich area of lots of exploration as to who's patenting what in there. So parking that part of the question aside, then are you left with what is the sort of copyright in the NFT itself? And yes, there is essentially an aspect of copyright protection for NFTs insofar as it meets our fundamental equation, right? You have to make sure that the NFT is original, that you have the rights to the NFT. You can't take a meme that someone else has produced and sort of apply an NFT to it and then claim you own the NFT if the underlying work was never your property to begin with, no more so than you can, claim copyright in a meme or, a GIF or something else that's going around on social media. So that's the quick answer to that one.
The only other one I found is how copyright for software development can be split among different authors based on their contributions.
So this one was talked about a little bit in a slide I had earlier about the piecewise aspect of copyright production. And so if you're getting together to create a work under open source, there's going to be a lot of people hopping on and hopping off the bus over time. You're not sort of working as a team within a certain sort of sprinting period to develop the code. And so in that situation, think of them as blocks, almost like Tetris blocks of code that are going to be protected under different copyrights. So the authors that release the initial code might have copyright in the original block, but then there'll be modules that get added to that by other contributors. Those other contributors will be able to put their copyright notice on their contributions. And if you're keeping track of changes, like in a GPL environment, that's fairly easy to do. You just have to put comments or headers that say, this module was created by the team at, Berkeley, not the team at MIT up above. And you kind of see this piecewise, copyright layers being built over time. It gets a little bit more interesting when those layers are being sort of fused more like a Jenga tower than a Tetris tower. When you're sort of inserting lines of code in other people's, then you have to it can get kind of jumbled very quickly as to, who owns what. But nonetheless, there are sort of tools in GitHub and other ways of making sure those types of authorships are accounted for and covered. Now, that's if you're doing it in an open source environment with people hopping on and off the bus over time. If you and a few others are just building a piece of code collaboratively at the same time, then it's more like the traditional, we want all of our contributions to be considered an inseparable whole, in which case copyright is 100% owned to all those authors at the onset. Any other questions, Aidan?
I don't think anything that can be answered this quickly, so we can hand it off to Robin.
Okay. Robin, back over to you.
Wonderful. Thank you so much, all. It was great to have you, and keep an eye out for all of our other sessions that we have, and enjoy the rest of your day. Thank you so much, Dan and Aidan, for joining, and it was a pleasure to have you both. Bye, all.